Okay, welcome, ladies and gentlemen, to our webinar. And this is the fifth webinar in the series since we started with the lockdown in South Africa. But this one is a practical one, hopefully, on the Unemployment Insurance Fund Temporary Employee Relief Scheme, the Temporary Employee Relief Fund. And as always, I would value your comments, your suggestions, your questions, your answers. Please feel free to unmute your microphone when you wish to make a contribution. Your microphone will remain mute in the interim, so please don't feel affronted by the fact. All right. So I hope everybody can see the screen. And the screen is talking to you about the fact that we are talking here about the UIF Temporary Employee Relief Fund and everything to do with that fund. Now, it's important for you to understand that the fund was created to compensate a company which is in distress as a result of the lockdown. And that it has ongoing obligations to employees who are not on sick leave or on normal leave. Now, a number of individuals have written to me and asked me to please explain this because they're getting contrary advice, sometimes from their own HR or industrial relations people. So I'm going to attempt to do it in a clean and a clear way. Prior to the UIF TER scheme being gazetted, South Africa was put into a lockdown. When we were put into a lockdown, the only mechanism that many employers employed or used to deal with the lockdown, where in fact their doors were closed, but they were having to pay their employees, was to say to their employees, you need to take leave. And at the end of the leave, if you've got no more leave due, you need to take unpaid leave. So the reality, ladies and gentlemen, is that that's our Basic Conditions of Employment Act, and it's absolutely illegal, and no one can tell you it's illegal. Not even, by the way, the Minister of Labour, who is prognosticating all over the place about how illegal it is to force people to take leave. Well, it's actually not illegal to force people to take leave. We're governed by the Basic Conditions of Employment Act. However, with the introduction, before I say that, let me say this. You're asking them, in the absence of the UIF TER fund, you would have been asking them to take leave, not sick leave. The only instance in which they would need to have taken sick leave, or you could have enforced them taking sick leave, is with the presence of a doctor's certificate, basically saying that they need to go off into quarantine because they've tested positive. So ordinarily, you would have said to them, take leave. Then along came the UIF TER fund, and the UIF TER fund said, we think it's unfair to expect your employees. We acknowledge it's unfair for you to expect your employees to take leave because, quite frankly, we caused the problem, not the problem, but we basically made a decision. And in the process of making a decision, we put you into lockdown. So as a result, we're going to try and compensate you as much as we can. We've created a 30 billion rand fund, which we anticipate to be able to last for 3 months. Lockdown is only 3 weeks at this stage, but the fund that we've created, we anticipate it lasting for 3 months if lockdown is extended, and in fact, if we in fact need to deal with a longer period of time for lockdown. So it's critically important that you understand that as a period, ladies and gentlemen. With the introduction of that, the UIF, the Unemployment Insurance Fund's Temporary Employee Relief Scheme, with that came the fact that it's no longer necessary to say to employees that they have to apply for their normal leave during the lockdown. But, and this is critically important that you understand it, outside of those employees who are making 3,500 Rand or less a month, the UIF TER scheme is not going to pay 100% of that person's salary, which means that there is going to be a shortfall. Now, remember, you've got an employment contract with the individual, so you have to pay them what you owe them, and you're able to supplement what you have to pay them with the UIF TER scheme, but there's always going to be a shortfall. You are not required as a company to fund that shortfall. There are some industries where the Bargaining Council has implemented what is called special leave, which might assist in the employees being funded without having to take normal leave. But ordinarily, employees are going to have to share the risk here. And sharing the risk means that they're going to have to take normal leave for the difference between what they're paid and what the UIF TER scheme will refund. And I use that term consciously. What the TER scheme will refund eventually to the employer. So they're going to have to take normal leave for that benefit. And so you will work out the difference. You'll work out the formula in relation to normal leave. And so you'll say to them, these are the number of days you're going to forfeit of normal leave for you to get paid your full salary. However, and there are a couple of labor lawyers who've been making the rounds saying it's unfair for you to expect your employees to take leave or paid leave. You are obligated to say to your employee, we will give you a choice. Either that gap gets filled by unpaid leave, in which case we don't plug the gap between what UIF TER pays and what we've paid you, or you take leave for that benefit and therefore you'll be paid your full salary. That's all those legal experts are saying. They're not saying that as a company you have to pay the difference, you have to supplement the difference between what the UIF TER is and in fact what you have to pay the person at the end of the month. There are some people who said to me, but that's immoral in these times. The employees are going to need that leave and there's no reason they should be punished. It's quite true. But the same level or sense of morality can be applied to the employer. Why does the employer have to bear the full risk of the lockdown when the employer and the employee share that risk, share that burden, and therefore share that obligation? So those are the considerations. So again, the fund was created to compensate a company which is in distress as a result of the lockdown, which has ongoing obligations to employees who are not on sick leave or, in fact, on normal leave. And again, please feel free to ask questions or make statements if you wish to. Right, moving on. It doesn't relieve the employer of having to honor its contract of employment. It compensates part of the employer's salary payroll expenses after the fact, after those expenses have been incurred. It is therefore a rebate and will not result in a prepayment. The UIF TER scheme will not result in you getting the money before you have to pay the employee. It will result in you paying the employee and then essentially having the rebate paid back to you by UIF. So you do need to be aware of that. You can't have retrenched your employees for purposes of the lockdown in isolation, which means they're still your employees, which means you bear the responsibility to pay them their normal salary on a monthly basis. All this is how you recover some of that money, not all of that money, some of that money. I see someone has unmuted their microphone. Pumla, is that you? Do you want to say something? And then Retha as well, I see. Do either of you want to say anything? No? All right, moving on. So in paying the employee's monthly salary, employers must recognize that the TER rebate will set off part of the salary expense, and unless paid at the minimum wage, which is 3,500 Rand, never the total amount. In applying to the Unemployment Insurance Fund, the key documents which are required, where the Department of Labor, the UIF, stipulate, and the Commissioner of the UIF has gone on radio to say, we will verify. Now, the reality is that the UIF do not have the capacity to verify every single application, but they'll certainly randomly select and verify. And so what you need to know is whatever you claim, whatever you submit to UIF might be checked either before they pay you out or in fact after they pay you out. And the memorandum of agreement, which we'll cover a little later, makes it very, very clear that they reserve the right at any stage to verify. And if they find that there's a false claim, they reserve the right to claim back any monies forwarded. So these are the things you're going to require. Number one, a letter of authority on an individual company letterhead granting permission to an individual specified to lodge a claim on behalf of the company. So your bookkeeper or your payroll clerk, whoever it is who is lodging the claim to UIF Temporary Employee Relief Scheme, whoever that person is needs a specific letter of commission from the board or from the CEO or from the chief financial officer of the business of the company. And that needs to be submitted along with the rest of your claim. Number two, a memorandum of agreement, which is a completion of the agreement between the Unemployment Insurance Fund on the one hand and either a bargaining council or the employer. So a bargaining council would have a collective response. Some bargaining councils would have a collective responsibility to make an application to the Unemployment Insurance Fund on behalf of the collective of its members, get the money from the Unemployment Insurance Fund, and then pay out its members when it receives that money. An individual employer would go directly to the UIF, enter into a memorandum of agreement, and the UIF would pay the employer directly and not a bargaining council if a bargaining council doesn't exist, or if you haven't if you have received from your bargaining council, if you are a member of bargaining council, a letter saying that you can go directly to the UIF. It is only in instances where the bargaining council agreement says that UIF claims will be done by the bargaining council where you need to go through your bargaining council. Otherwise, you will go directly to the UIF with your memorandum of agreement. It's important to note that the memorandum of agreement is only applicable to employers of more than 10 employees. So you do not have to enter into a memorandum of agreement, have it signed by the UIF department if you employ less than 10 people. I did receive a question from an individual who is self-employed and pays UIF on their own behalf. You do not need an MOA in your case. You can submit directly to the UIF department without needing a memorandum of agreement. From 11 employees onwards, obviously, you have to have a memorandum of agreement. There is a prescribed template that requires critical information from the employer about the employees on whose behalf you're claiming. That will be sent out a little later after this presentation. I will send you all of the forms. And thank you very much to all of those people, including you, Dave, who've been sending me those forms as a result of your interaction with the Unemployment Insurance Fund. I do need to just as an aside, bring your attention to something, and that is those of you who are dealing with Unemployment Insurance Fund seem to believe, or some of you seem to believe, that that you have a whole lot of people sitting on the other side of the phone or over the internet that are communicating with you. I hope by now you will have realized that the moment you send in a query, they send you back an automated email, and that in fact, at the very best, they're working remotely, but the majority of people who are responding to you are responding on a rotational basis on the system rather than physically they are there. There are one or two individuals who say they've spoken to these individuals, which is fantastic. But I do want to warn you, it's going to be very, very difficult to get hold of a particular person at this moment in time, simply because of the load on the Unemployment Insurance Fund. Having said that, there are people who have managed to get through, so I'm not making fun of that in any way. I just want to read some of the questions. So one of the people asked, is the TER's benefit taxed? At this moment in time, the memorandum of agreement makes allowance for the temporary employee relief program or scheme payments to be taxed, but what's what I'm looking for? They neutralize their obligation as the UIF to be paying that tax. All of the regulations up until now, those regulations are silent. We do not anticipate that it's going to be regarded as an income and therefore taxable. Certainly, the Treasury and SARS have been absolutely silent in this regard. However, one never knows what's coming down the line. So be prepared for the possibility, although I don't think it's a probability. Number two, what about those small companies that open but working on a lesser time? For example, 5 hours per workday and remotely. All right, so in that instance, you are not locked down. If you are not locked down, the UIF will compensate for short time, where an individual can show that a company is not paying them their full salary, but has reduced their rates, etc., or rather their hours, etc. However, that application is not done by the company. That application will be done by the individual to the unemployment insurance fund to supplement essentially the difference between their normal working salary and what they're being paid at the moment. But obviously, there's a process. Please remember, ladies and gentlemen, there is a 189 process you have to engage in before you do that with your staff members. They have to agree in writing expressly after a consultation process to allowing you to cut back on their wages, etc. So please be aware of the Section 189 process in response to that question. Bum, 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 bum. All right. Is the 3,500 Rand minimum wage still multiplied by 60%? No. So the 3,500 Rand minimum wage will be paid out at 100%, and anything less than, if you're not paying minimum wage, so you might fall into an industry that has a statutory determination that doesn't require minimum wage for whatever reason, then in fact, up to 3,500 Rand, 100% will be paid by the UIF TER scheme. It is only above the 3,500 Rand that the 60 to 38% sliding scale kicks in. There is a UIF calculator. That calculator has been made available on the WhatsApp group. I will make it available again when I send out the documents from this presentation. It is not 100% reliable as a calculator because remember, the variation for the 100% to 3,500 Rand wouldn't have been factored into that calculator. It is generally the calculator that is used for UIF calculations. And then finally, is the TRS benefit prorated for 15 days? Though so won't be a full monthly salary. You are fully entitled to prove at on the 15th of August or the 16th of August when you submit to UIF, or at the end of, sorry, when I say August, I mean April. I apologize for that. At the end of the month, essentially, you're fully entitled to show that there was a full lockdown for three weeks, and therefore it won't be prorated. The benefit is available for the period of the full lockdown. It is not available for a month-by-month payments, in answer to your question, Phil. Right, so moving on. So the prescribed template is very, very important. Evidence of payroll as proof of the last 3 months of employees' salaries. So you have to show that the employee has been on your payroll for a minimum of 3 months and that you've paid them for a minimum of 3 months. That's critically important, ladies and gentlemen. Confirmation of bank account details in the form of certified latest bank statement. So you can either have a letter from the bank to say that this is your bank account, and you submit that letter, or you have certified latest bank statement. It isn't always necessary to supply your 3 months of bank statements to the UIF. They reserve the right not to accept the letter from your bank, but to insist on the bank statement. You are entitled to reserve those statements and say the bank account letter suffices for evidence of the bank account itself. It all depends. Someone said to me, does it depend on what we're hiding? And the answer is yes, it depends on what you're hiding. Bill asks, what about foreigners with a work visa? Bill, if the individual, and it's exactly the same as labor law generally in this country, which applies to anybody who is legally working in the country, who you employ, on whose behalf you pay UIF, Unemployment Insurance Fund contributions. As long as you're paying an unemployment insurance payment on behalf of the individual and they have a visa which allows them to work in the country, an ASLAM or whatever it is which allows them to work in the country, then you are entitled to claim UIF on their behalf and they're entitled to claim UIF because, in fact, UIF is an insurance policy. Your question only really has resonance for foreigners who do not have a work visa, because then obviously you cannot claim on their behalf. And more importantly, if you have not registered for UIF and you are not paying UIF generally, then you cannot claim. It's simple. UIF is an insurance policy. You're paying UIF so that you can claim UIF. Must the employee prove in distress? Must the employer prove in distress? Absolutely. And in distress is as much or as little as our doors are shut. We're not trading. We can't trade. So you cannot claim unemployment insurance fund TER, well, let me talk in absolutes and then I'll talk in specifics. You cannot claim TER benefits if you're an essential service. However, if part of your business is shut down, then for the part of your business which is shut down, which is not essential services, you can claim TER benefits. But for the part which is still operating, you can't claim TER benefits. If you are one of those companies that have one foot in essential services and one foot out of essential services, it is critically important that you send through a clarifying letter which makes it very, very clear what side of your company is shut down, which employees are affected by the shutdown, and which employees are not affected by the shutdown and regarded as being in essential services. I hope that answers your question, Laurentia. Uh, da, 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 da. Annalise asks, do you have to open a separate bank account for these deposits? Well, that's very interesting, and thanks for that, Annalise. So I've actually just answered someone in this regard before we started today's session. So the bottom line is this, that the memorandum of agreement makes it clear that if you are a bargaining council, you have to open a separate bank account. The commissioner, when he's done his radio interviews, has made it clear that private companies do not have to open separate bank accounts. However, a prudent accountant might say there is no harm in opening a separate bank account because we could be called upon by the UIF to account and to submit audited accounts of how we've used the UIF funding which has been received. And therefore, it makes it a lot easier if you do have a dormant account, a spare account, or a new account that you can utilize so that all of the money coming in and all of the money coming out or going out relates specifically to UIF TER. Ayanda says, hi. If you are a company that has less than 10 employees and therefore do not have to sign an MOA, do you still have to open a separate? No, you don't. Ayanda, you can basically utilize it within your existing bank account. Well, that's what the UIF department have said to date. They might, who knows, they might vary in the course of the next week because it's a little bit like our transport minister, winging it. They might come back and say, hold on a moment. Whereas we said private companies don't have to open bank accounts, we are now gazetting the fact that you do. So I would say err on the side of caution and open a separate bank account for purposes of the UIF. Remembering this, and I don't want to burst the bubble, but I have to burst the bubble. Remember this, that you are at least 45 days away from getting any payment back. Initially, when the scheme was launched, the UIF commissioner said we're going to be paying out within 7 days. However, the Gazette itself has been silent, and the example of the memorandum of agreement, which is included in the Gazette, now says that you will submit on the 15th of the month, you will be verified against your submissions, and you will be paid within 30 days of submitting the invoice on the 15th of the month, which means that you will be paid. If you submit on the 15th of April, you will receive your UIF TER tranche back by the 15th of May. I'm firmly of the belief that the president will put significant pressure on the UIF commissioner to change that. What you've got to remember is that the memorandum of agreement, which has been published, was established for purposes of what was referred to as the temporary layoff scheme, not the temporary employee relief scheme. The temporary layoff scheme is a scheme which has been on the books for the last 10 years. If you're retrenching, you can apply to the CCMA, who has access to the UIF for the temporary layoff scheme. And what that does is it's money for training, retraining, for RPL, etc. So the memorandum of agreement that was put together for that purpose, not for purposes of the temporary employee relief scheme. So I'm firmly of the belief that significant pressure is already being put on the commissioner, and we might very well see a Gazette varying the payment undertaking to within 2 weeks, if not a week, because they realize you very much depend on those cash flows. But as things stand at the moment, I do want to caution, you are obligated to make your payments at the end of the month of your employees' salaries because you haven't retrenched them, you haven't let them go. You're obligated to make your payments to them and to then recover some of that money from the UIF TER. You cannot wait until the UIF TER has paid you before you pay your employees. It is an unfair labor practice for you to turn around to your employees and say, we're not paying you until such money as we've got back the money from the UIF. You can't say that. I don't even want to say unfortunately. You just can't say that. I just want to make sure I'm not skipping or missing any questions here. Would it be easier to run two payrolls for the month, one for UIF portion and another for the balance to show the proof of allocation of the funds easier? Um, I don't necessarily think so, and the reason I don't necessarily think so, Annette, is because your reconciliation and accounting and auditing for the UIF component of your payroll has nothing to do with the payroll itself. It's a recovery. It's money in set off against payroll, sometimes not even set off against payroll. And you've got to be very careful about that, by the way, because even though you can justify with a reconciliation, we've paid up front. Therefore, any UIF money coming in can be apportioned to any account. It could be regarded as income, or it could be regarded as paying off loan accounts, or whatever it is. You shouldn't do that. It should go into payroll so that there's a clean reconciliation. So, in answer to your question, Annette, I don't think you can. I don't think you necessarily should run two payrolls, but how you manage it is absolutely up to you, as long as your auditor approves. And I'd get your auditor's approval before you commence rather than after. In this instance, it's much better to ask for permission than to ask for forgiveness. Kulu says we have employees that started in January 2020. They don't have sufficient leave. Well, two things, Kulu. They don't have January, February, March. They don't have sufficient leave. Well, actually, they don't have sufficient leave, but you would have sufficient proof of 3 months worth of payroll to them by the time you claim. So that's fine. If they don't have sufficient leave, then in fact, all they're entitled to be paid out is the UIF TER contribution. However, and this is critically important for me to reiterate again, you have to pay them at the end of the month and claim the money back from UIF, which will take a lot long, not a lot longer, but will take longer for you to recover. So you're going to have to pay them out and notify them of the fact that because they don't have any leave due and you're not giving them any special leave, that the maximum you're going to pay them out is in terms of what the calculator says they're due, that you know you'll be able to get back from UIF. Mary Rose says, if you fall under the Metal and Engineering Industry Bargaining Council, are you compelled to do an MOA with them, or can you do it directly? That's such a good question, Mary Rose. What you have to do is you need to get hold of the Metal and Engineering Industries Bargaining Council. If you can't get hold of them, if you try to phone them and they're locked down or they're not even working remotely, then you can simply use that as evidence to the UIF of why you're going to them directly with their memorandum of agreement. However, it is unlikely that any bargaining council at this stage during lockdown is taking on the responsibility to manage the UIF claims on behalf of all of its members to UIF for TER. So it is unlikely any of them want the job anyway. So I think you can take it as granted that it's much better for you to submit the MOA directly to the UIF department, and we'll talk about how in a minute, and ask them to sign it. If they come back to you and say, but why didn't the bargaining council sign it? You'll say because the bargaining council is inaccessible, they're also locked down. And then the UIF will have to come out and say, but hold on a moment, we have an agreement with the bargaining council, but they wouldn't have an agreement. There is not a single bargaining council that has an agreement. Well, let me add a rider. There is not a single bargaining council that I am aware of, and neither you, the UIF, nor the bargaining council fraternity have made it public. There is not a single bargaining council that has an agreement with the UIF to manage UIF TER claims on behalf of their members. There is not a single bargaining council agreement that makes allowance for that either. So, unless they've been running around and rushing around, in which case they must have told you by now, you can take it for granted that you have to do the UIF agreement directly between your company and the UIF. That's Mary Rose. Aggie says, is there a limit to the size of a company that has a right to the benefit? No, there's absolutely no limit. There's no limit to the size of the company. The only limitation is this. And for whatever reason, there's been a lot of confusion. There's a lot of sort of self-proclaimed experts out there. You might say, but hold on a moment, I'm proclaiming to be a self-proclaimed expert as well. Yes, I am. But there are a lot of self-proclaimed experts out there running around saying this, that you will get back 38% of whatever salary you're paying in your business, even if the salary is 60,000 Rand. That's not true. you will get back 38% of the ceiling of UIF payments, which is 17,750. So, Aggie, in answer to your question, there's not a preclusion on the size of the business, but there is a preclusion on how much money can be claimed. There is a ceiling on what the UIF will pay out for. So if you're making 60,000 Rand, it will pay out 38% of the first 17,750 Rand and not beyond that. But we'll talk about that a little later. But there's certainly no restriction on the size of business. And I'm not aware of any bargaining council that has asked the UIF to impose such a restriction either. What if there is just no cash in our accounts to pay any of the salaries? Look, if there's no cash in your account to pay any of your salaries, then the bottom line is you need to make it clear. You need to enter into a 189 discussion, Section 189 discussion with your employees, where in fact you give them the option of waiting for the UIF payment until such time as you receive it, or in fact severing the employment relationship with your business and being retrenched in the full knowledge that the company does not have the liquidity to pay out a retrenchment package, principally because of the lockdown. So you need to give them that option if you do not have the cash to pay them. The option is agree that you will wait for the money, or agree that you will be retrenched, in which case there is nothing to pay you out, and you're more than welcome to go to the CCMA when it opens, or a bargaining council when it opens, or collectively to the Labour Court when it opens, to try and get the money from this company at that stage. But then, by then we might have reopened already. And please, I know I'm sounding crass and sarcastic, but that is unfortunately the discussion you have to have. And please, I do need to emphasize from a labor relations point of view, and this comes out of years and decades of labor relations, you cannot dismiss, you cannot retrench people because of the lockdown. So you need to understand that. You can give them the choice to be retrenched, but you cannot automatically retrench them. You can implement a Section 189 process where the first option on Section 189 process is wait for the UIF repayment, because we anticipate that the lockdown is temporary and we will be opening our doors again. The only time you will retrench is if you know you're not going to open your doors again. And in that case, you still have to be procedurally absolutely correct in how you implement your Section 189 process. So please be aware of that. You do not want to run foul of that. You have the moral high ground. You know you're going to get the UIF TER back. You know you can show you're a business in distress. Don't give away your moral high ground by being unilateral, by committing an unfair labor practice where you know that you're going to get knocked by a CCMA when it reawakens, or a bargaining council, or in fact the labor court. Please be very, very careful about that. Okay, I'm going to read the next couple of questions and then I'm going to carry on with the presentation. Thank you for all of these questions, by the way. Annelies Stolz says, what if there is just... No, all right, we've answered that. Manka says, what about contract workers, people that get paid on a weekly basis? Manka, I don't know what a contract worker is. You either have a permanent employee, or within the 3-month process, you have a temporary employee. If you have an agreement with a temporary employment service, then the employee is still your employee because of deemed employment status. So I'm not certain what you mean. If you are paying UIF on behalf of any employee, be it an employee who works some hours or an employee who works all hours, they will qualify for the sliding scale of 60 to 38% against what their average monthly income is, irrespective of whether it's calculated on a full month or whether it's calculated on a part month. Mr. Kozilski asks this question. What are the rules when the whole company is working remotely, but at the end of the month, your income retainers or income received is severely reduced? Okay, Mr. Kozilski, what happens in that instance, sorry, I think it's Adele. Adele, what happens in that instance is it's not the company that will be making the UIF claim. It is the individual who will be making the claim on their own behalf because they've been given from the company, they've been given the right documentation to show that procedurally correctly, of course, their hours have been reduced. So in that instance, you will apply for essentially for UIF payments to you as an individual for the gap or for a percentage of the gap as the sliding scale is applied, for the percentage of the gap between what you ordinarily make and what you've made because of a reduction in the hours of work. However, I do need, not however, and I do need to say this to you again. If your company is operating and your employees are working remotely, which means they're working from home, then your company is not in lockdown. If your company is not in lockdown, you cannot prove distress. If you cannot prove distress, you do not make a claim to the Unemployment Insurance Fund's temporary employee resource scheme. You do not make a claim to them under the TER scheme because, in fact, you cannot show that you're in lockdown. You cannot show you're in distress. TER would be the wrong thing that you're actually claiming for at the end of the day. If you have already completed the originally required, but you actually need, sorry, these questions are coming in thick and fast. Need to submit to TRS what you do now? Okay, that's a good question. So, and I've had a number of these questions. So the question is this: before UIF came in, or rather before TRS was introduced, we said to our employees, you have to apply under your normal leave provisions. And the employees were then entitled to make their normal application to UIF. You are entitled to ask the UIF to vary your application because of the introduction of the TRS scheme. It's that simple. Janelle, what happened to the sound, or is it me only? I hope the rest of you can hear me. I certainly hope the rest of you can hear me. Can I just get an indication from anyone? Because Janelle seems to think that you can hear me.
I can hear you fine.
Okay, fine. Thanks for the question, Janelle. Okay, everyone's coming through now. Yes. Okay, good. All right. I'm gonna ask one more of these questions, and then we're gonna carry on with the presentation. Rates between 38 and 60%. Has that sliding scale been released? There is a calculator which has been released that can help you calculate the rates, remembering that you would start from 3,501 Rand upwards. And it starts at 60% and it goes all the way up to 38% of 17,750. So if you haven't got the calculator, please, well, in fact, I'll send a link to the calculator out again when I send these notes out. Good. I'm going to ask this question and then I'm going to move on. Sean says, why are you obliged to pay? If you are guaranteeing that they have a job, however, surely there is no work, no pay allowed to be applied. E.g., you are a retailer who can't operate stores. Sean, because you have an employment relationship with them, because you haven't engaged in the Section 189 process, you've not fired them, you've not dismissed them, you've not retrenched them. And therefore, you have an obligation to continue to pay them, irrespective of whether you're trading or not. Government have implemented a lockdown, and government have said, because we've implemented a lockdown, we're implementing a subsidy scheme called the TER scheme. And there are other schemes, by the way, that the DTI, Department of Trade and Industry, are implementing, and the SME department are implementing to compensate companies for losses. But this is not that scheme. This scheme relates specifically to your employment relationship. The scheme relates specifically to your employment relationship. Whoa, that was interesting. Okay, so moving on. All right, so So all documents must be submitted to one email address, clearly identifying your company name, your registration details, and the name and contact detail of the person making the submission, remembering that you have to give the person making the submission a letter of authorization to make the submission. All of that then gets emailed to COVID-19 UIF claims at labour.gov.za. I know that the UIF are in fact answering, maybe not to the not at the rate you would hope for and not at the speed you would hope for, but they are certainly answering. They're acknowledging where they can. I have also received a number of complaints from people who say that they're not getting an acknowledgement, they can't check up, they phone the numbers and the numbers are not answered. But I think you have to understand, ladies and gentlemen, every government department, but specifically in this instance, the UIF, are in a state of absolute chaos, only caused by the current situation. I suppose I'm being a little flippant when I assume that before COVID-19 they were operating flawlessly and seamlessly. But certainly, even if they weren't, this just makes it a lot worse. So please just be a little flexible and a little patient with the UIF department. The reality is 30 billion rand has been set aside to pay back to you. It is real money. There is nothing that's disingenuous about this process or about this scheme that's been set up. So please, I think you have to understand the predicament of the situation. Um, that we're dealing with. New question has come through from Paul. Uh, how soon do we have to discuss the option with staff for forfeiting leave? And does it have to be in writing? It has to be discussed as soon as possible. And any decision has to be in writing, Paul. You've got to be very, very clear about that. It has to be discussed, which is a Section 189 process. Remembering Section 189 is not only about retrenchment, it is about any variation to a basic condition of employment of your employees. It is about any of your contractual obligations to your employees. So please commence with that process. Payment will only be affected after the memorandum of agreement has been signed by the fund, and therefore please send the memorandum of agreement as early as possible to that email address, COVID-19 UIF claims at Labour. Send it as early as possible so that they can sign it. I'm not aware of the UIF at any stage saying we're not going to sign it. In fact, I'm not even aware of the UIF coming back to any of my clients and saying, what does this mean? What does that mean? Or where is this document? So what I'm trying to say is they will sign it unless they've got a problem, in which case they'll make it very, very clear to you. So this is important. If you fall into an industry or a sector which has a bargaining council or is subject to a Department of Labor, a Minister of Labor's statutory determination, which is a government gazette that says, here is the minimum wage you have to pay this group of this job title of employees. So, for example, there's a statutory determination for domestic workers, as an example. There isn't a bargaining council, so therefore the minister has taken it upon itself. A ministry has taken it upon itself to develop a statutory level of minimum payments for domestic workers. So either if there's a bargaining council or a statutory determination, then in those instances, there will be a national minimum for that sector and for jobs in that sector that must be stated by you, the employer, and you must submit to the UIF a copy of what you've got either from the bargaining council or the statutory determination that would have been gazetted by the Minister of Labour, showing what the national minimums are for those jobs and those job categories. And you will get those, by the way, from your employer association if you're a member of a good employer association. You can ask your trade union. Trust me, your trade unions know exactly what those minimum wages are. They'll be able to give them to you if you haven't got them. Or if you're a member of a bargaining council, then you can go directly to the bargaining council. Even if you're a non-party of a bargaining council, which means you're not a member of an association which is a member of the bargaining council, but the minister has extended the bargaining council agreement to cover you, even if you're a non-party to the bargaining council, then in fact you will be covered by the agreement and those minimum wages will in fact apply. If you're not covered by a bargaining council agreement or any statutory determination, if you're not, then the national minimum wage of 3,500 Rand will apply. And it's crucial and incorrect. It's crucial that any incorrectly stated values could slow the process down. I think that's a slightly disingenuous statement in the procedure by the UIF department because they're not going to have the opportunity to investigate every single claim. But what they're doing is they're reserving the right after all of this is over to go back and say, well, what did you claim? Was that the minimum wage? Is that what you were paying the person, etc.? And then, of course, they're going to say your paperwork needs to be in order. Right, the additional points you need to take into account, ladies and gentlemen. The opening of the special account is only applicable to bargaining councils at the moment in the regulations. However, better practice is open your own account. If you represent more than one employer, in other words, you're an agency or you're a broker, please submit one template per employer. Each of your applications to the UIF have to be individualized. The means to payment is critical, and provide banking details as per the mode selected. For example, if the payment should go to the employer, then the employer's special banking account should be given or to the UIF, or your general banking account should be given to the UIF. So the means to payment is critical. If the UIF don't know how to pay you, they won't pay you, and you can't blame them for that. So you need to give them proof of the banking account that you want them to pay into. Proof of payment is required to satisfy that the payments indeed went to the employees. This is also critical if further payments are required. So it's a cart and a horse situation. When you apply on the 15th, by the way, you won't have proof of payment. So you might need to do a special payroll run when you open on the 17th. However, if you want to reserve it to the end of the month, the UIF will allow you to reserve it to the end of the month. But you're going to have to show that you've actually literally run the payroll and that you're submitting proof of the payroll having been run to the individuals. And where that becomes important is not so much for the first payment, but if there is an extension, because remember, this scheme has been created for a 3-month period to be running. They've created the scheme as if lockdown was for 3 months. Where that becomes important is if we have an extension of the lockdown beyond the end of April, you will have to have been submitting proof of payments to the individual that you've not interrupted their contract of employment waiting for UIF payments. So I cannot emphasize that enough. There is an inquiry telephone number to phone and ask, did you receive my claim? And that is 012-337-1997. This presentation, by the way, will be distributed to you. 012-337-1997. As far as the memorandum of agreement is concerned, if there is a bargaining council in your industry or sector, get a certificate from the bargaining council to deal directly with the UIF if the bargaining council is open. If the bargaining council is not open, then you can always say to the UIF, we're coming to you because the bargaining council is not open. We are coming to you directly. Number one. Number two, this is not the training layoff scheme. The memorandum of agreement was created for the training layoff scheme, where the bargaining council would administer a training layoff scheme on behalf of its members and enter into an agreement, funnily enough, not with the UIF, but with the CCMA. This is not that scheme. So you need to be aware of the fact that in the scrambling to get the regulations out, some of these documents do confuse the temporary layoff scheme of the Department of Labor and the UIF and the CCMA, confuse the temporary layoff scheme with the temporary employee release scheme, which is what we're talking about today. So please just be patient with that and show an understanding with that, and vary your documentation on the basis of understanding that it's not the TLS scheme. As I said, the agreement will last for 3 months so that if lockdown is extended, you will have an agreement already signed to cover the lockdown. Now, just pulling out some of the clauses of the Memorandum of Agreement. 4.8, the employer shall account for the expenditure on the previous tranche payment before the next tranche can be processed. I've spoken about that already. 4.10, the COVID-19 benefits will not be paid to employees appointed after the commencement of the agreement. So this agreement will be signed by the end of April. If in May you have appointed new staff for whatever reason, but the lockdown is still going on, you understand it's a non-possibility. That was 4.10 was actually put together for the temporary layoff scheme, but they have relabeled it COVID-19 benefits. So I'm going to read that again. COVID-19 benefits not be paid to employees appointed after the commencement of this agreement. It's an impossibility, but it might be that, for example, you're a company that has 1 foot in and 1 foot out, some essential services, some non-essential services, and then you move people from essential services into non-essential services, or you move people from essential services into the lockdown component of your business, they will not qualify for this benefit. You need to be aware of that. So you need to tie your flag to the mast in terms of what is essential what is non-essential now, and you can't vary that and expect to get TER down the line at a later stage. Sorry, is there a question there? No question. Okay. I'm just going to mute again. Okay. Moving on. The COVID-19 benefits are for the benefits of employees and as such constitute workers' funds, and hence the UIF will not be liable for any management fees or any additional costs whatsoever. That goes to the brokers out there who will manage these applications on behalf of companies. Please, as companies, be aware of the fact that you cannot deduct a management fee, whether it's 10% or 50% of what is received from the UIF for this purpose. You cannot account to UIF showing that you paid your management fee out of the income received from them. Any management fee would have to be paid over and above what you're receiving from the UIF. And there are some brokers out there who are starting to go around to companies and say, we'll take a percentage of what we recover from UIF for you. That's illegal. It's an illegality that will not be permitted, will not be allowed, and you're actually committing a criminal offense if you take any of the funds away for that purpose instead of for what it's intended to be used for. So please be aware of that, ladies and gentlemen. In relation to all 3 monthly payments, the employer must submit documents as stated in Annex A, and we're going to go over that in a minute of this agreement, on or before the 15th of each month. For verification, UIF should accept and agree with the employer on the submitted deliverables prior to processing payment on any invoice, as is reflected in this regulation. The UIF shall pay funds electronically into the bank account which you've proven is the bank account by giving a letter from the bank or your bank statements within 30 days of receipt of a valid invoice. So on the 16th or by the end of the month when you submit your invoice with all of the documentation and accepted deliverables as stated in Annex A of the agreement. We're going to go over Annex A. The first payment will be made after the signing of the agreement by both parties and verification of the documents. So please make sure you get a signed MOA. It's that simple. And UIF has the right to request financial documents to prove that the company was in distress during the existence of this agreement. Now, this is a gray area. It's an art, not a science. What you have to be able to do, and it's going to be, the only difficulty is going to be for those companies that have 1 foot in and 1 foot out. In other words, some of what you do is essential services, some of what you do is not essential services. But ladies and gentlemen, what you have to realize is that the UIF have the right to question the level of the distress of your business. So distress is commonly defined as a company that is in lockdown, shut its doors, cannot trade. If it's partially trading, the onus is on you to show that you're only claiming distress for the side of your business that is not trading. The problem is that the UIF don't have even internal guidelines on how to even analyze that kind of a submission. So you might need to be making the argument with them once, twice, 3, 4 times before they actually understand and before they agree with you to process the distressed side of your business's application. It's an art, it's not a science. And I know that's a common mantra I use, but it really is. It's how clearly you can make the argument. This is a distressed side of my business. I have completely segmented the employees. I might even have segmented the accounts. You can see there's no income over this period. The business is distressed. We cannot meet our obligations. We can't even meet our obligations to the employees, and therefore we're having to increase loan accounts in the business to make those payments. So you need in your own mind to know how you're going to establish distress. At the moment, there's no standard for distress. So you need in your own mind to know that you can prove distress for your business. Employers are required to sign an acknowledgement of debt if the contributions are not up to date. Now, this is a question I've been asked. What if I've been making contributions for my staff members, but 2 things. I might have been making contribution for a category of staff member rather than for an individual staff member, and that has happened before. Or I might not have been paying the full amount I should have paid because they've received increases and I've not increased my UIF contribution. So the UIF are pretty flexible in that regard. I don't know how flexible they're going to be now because of the pressure they're under. But generally, if you go to them and say, look, I need to regularize my UIF account with you because I've not taken into account increases, et cetera, they're pretty flexible. They say to you, sign an acknowledgement of debt that you'll pay over the next period or you'll pay in one tranche, whatever, and we'll regularize the account. We'll put that money to that individual's account so that if there's ever a UIF claim against that person's account, we'll pay out. They really are. I've never had a situation with a UIF, and I've been dealing with them for the last 10 years. In this regard, I've never had a situation with them where they've been unreasonable. There's no reason to be unreasonable. Okay. The memorandum of agreement makes allowance for the fact that you will partner with the unemployment insurance fund in educating your employees about what COVID-19 is, about what the UIF is, about social distancing, about all of the materials, all of the communication, education, promotional materials, which are made available to you from the UIF. You have to pass those materials on to your employee, and that is in fact contained in the memorandum of agreement. However, you're not obliged to print out what they give you and physically give it to the employees if it's not being sent to you in printed form. So the most you're obliged to do in terms of communication is send it to their cell phones or their email addresses, but you're not obliged to incur the cost of printing in this regard. All right, so let me finally get to Annex A. And Annex A is what's at the back of the memorandum of agreement. And the irony is that Annex A is imperfect. It is absolutely imperfect. And so what you have to realize about Annex A is that it was set up for the temporary employee, for the employee layoff scheme, for the training layoff scheme, and it's been customized for COVID-19. So, for example, it asks you to complete a COVID-19 benefits budget. In other words, in total, how much are you intending to be claiming over the 3-month period on behalf of all of your employees? It asks you to talk about the number of employees. It asks you to talk about the value of the COVID-19 benefits on a monthly basis, and then to reequate over a 3-month basis. As you can see, number 1 and number 4 repeat themselves, but just bear with the UIF, please. The schedule will be perfected along the way. And as you can see, they stipulate there on Annex A that the maximum amount that you can claim your 38% of is 17,712 Rand, even if you're paying 100,000 Rand a month to that employee. So those of you making 100,000 Rand a month who are on lockdown, you can claim 38% of 17,000, it's roughly about 6,800 Rand against your 100,000 Rand a month as UIF. The balance will have to be taken out of your leave. So what's interesting about the 6.1, 6.2, and 6.3 is this related to the training layoff scheme, and it's been amended now for the TER scheme. But as you can see, it's telling you what the 3 months, should our lockdown be extended for 3 months, it's telling you what those 3 months would look like. So in 6.1, it's telling you everything you need to be submitting. 6.2, it's telling you everything you need to be submitting and everything you need to have submitted in 6.1 in the first month to qualify for payment in the second month. And the same is in relation to the final payment. And really, these three, 6.1, 2, and 3, really have related to what bargaining councils have to do rather than employers. So you just need to be aware of that coming out of Annex A. And like I say, please be gentle in how you judge the UIF department. Remember that they've had to be clamoring around, and they've really not had a huge amount of time within which to do it. I just want to go to Charles and Kate's questions. Charles says, we had 2 new managers joining on the 1st of April. They received letters of offer on the 1st of March, and therefore we had to honor. We cannot prove 3 months payroll, so how do we claim for them at the end of April? The bottom line is, Charles, you would need to seek condonation from the Unemployment Insurance Fund for the first 17,700 Rand of their packages. I have no doubt that UIF will be sympathetic to your cause, but it will have to be applied for to the UIF in a separate letter, send it to that same email address, and they will eventually get round to you in that regard. And I'm sorry to sound so blasé and so dismissive, But I do not have a cut and paste answer for you, unfortunately. Charles, I apologize for that. Kate says, number 4 is monthly and number 1 is in total, I think. Thank you for that clarification, Kate. Number 1 says, what's your total annual budget? Number 4 says, what's your budget for the 3-month period? Okay, so it's not a repeat, or it's a repeat, but within the budget. Your COVID-19 budget would not be for more than 3-month period. In fact, your COVID-19 budget would be for a 3-week period at this moment in time. But I'd like to hear from you as you make these submissions, what the department is actually saying to you. Sean says, would it be sufficient to send a written communication to all employees advising them of the intention to apply annual leave to the lockdown period, or would that be considered to be acting unilaterally? Sean, you can't do that. You cannot. You see, you could have done that before the introduction of the TER system. Even though the minister was saying it was illegal, it wasn't illegal at that stage. But now that there is TER, you have to make it very, very clear that if you're asking them to apply for leave, it's only to plug the gap, and you have to be giving them the option of taking unpaid leave or taking paid leave to plug the gap. But you cannot say to them, well, we're expecting you simply to take leave for the lockdown period. So that is a unilateral unfair labor practice, but it's also an illegality because TER is now on the scene. A consultative process would surely be impractical for a company with a large staff component. Section 189 requires a consultative process. I know how impractical it is, Sean. Consultative process can be remote. It can be over cell phones. You can send out a questionnaire over the cell phone saying, please come back to us with any ideas alternative to retrenchment or any ideas alternative as to lockdown if you think we're an essential service, whatever it is. And you can have that dialogue, but you have to prove an engagement. You cannot run foul of a unilateral decision. The courts will say, if you couldn't engage in 189 at all, then the most you can be applying is paid leave, on the understanding that it would be plugging the gap and not paying for the full amount of the lockdown because you have TER at your disposal. So you have to be very, very clear of how you careful in terms of how you do that. If the lockdown period is extended beyond April 17th, how best could a temporary salary reduction be implemented? Again, a temporary salary reduction is a change to a condition of employment. It cannot be a unilateral change to a condition of employment, which means you've made that decision on your own and you've done it without consulting with your staff. It has to be Section 189 or at least consulted. Even if you don't call it Section 189, but you consult, that's more than sufficient. Because Section 189 scares people sometimes. It says, especially those people who've worked in other companies, it says, they're going to retrench us. This is how they start the retrenchment process. So you might just want to begin and call it a lockdown engagement process and not a 189 process. And retroactively, if you need to prove 189, it'll constitute 189. So you don't need to worry about that. The test is, has there been engagement, not what have you called the engagement. And Phil says, surely we can use TERSs for factory staff who aren't working at all and utilize annual and unpaid leave for office staff who will then receive more than a TERS claim. Well, I don't understand that. If your factory is on lockdown, then you can apply TERS to factory. If the rest of your staff are working remotely from home, then you can't apply TER to those staff members. If that's what you're asking, I'm agreeing with you. If, on the other hand, you're saying for the members who are at home, you're going to use TER to supplement their salaries, then you can't do that. That's illegal. You can't do that. Okay. I tell you what I want to do now. I will unmute your microphones, and if there are any of you who want to ask a question rather than type a question, I'll be only too happy to entertain you asking a question. So I've unmuted your microphones. Please feel free.
Ivor, hi, it's Dave here. Can you hear me?
Yes, I can, Dave.
Ivor, I'd just like to refer you to the definitions part of the MOA, where it requires us, as far as I'm aware, to fill out, it's on page 3 of the MOA under the heading Council/Employer. It's asking us to fill out means the National Bargaining Council for the clothing manufacturing industry to be registered in accordance to the laws of the Republic of South Africa.
Right. So, Dave, let me answer your question, please. And thank you for that. So remember, I said that this agreement has been Bastardized isn't the right word. It's been adapted from the MOA, Memorandum of Agreement, that related to the temporary layoffs, or to the training layoff scheme. And so that clause on the MOA hasn't been taken out, and it relates to one bargaining council in the training layoff scheme. So just take that as an example. You can ignore anything that refers to council or a bargaining council. You can ignore it. You take it out, you can change it.
And then still on the same page, under COVID-19 benefits, it says means an amount equivalent. Oops, sorry, it's just disappeared off my screen for a sec. Means an amount equivalent to something of the equivalent of the employee's normal wage. Would that be equivalent? How would one interpret that?
No, so that is exactly that point I went over before. If there is a bargaining council minimum wage determination, or if there is a statutory determination because you don't fall under a bargaining council, that's what you would need to be referring to in that formula. In other words, a minimum wage for that job.
So under the definition.
So
you don't have to. You list each one individually. Then?
You list each one individually. So you include it. So, for example, a bargaining council would have a minimum wage per Patterson band, for example, or per job category. And so, for an individual, you would classify them, for argument's sake, as an A55. If there were 55 jobs in A category, and you would say for A55, the minimum wage is 10,000 rand, and therefore we are claiming. I'd imagine it would be about 45% of 10,000 rand from the UIF TER system. But there's a calculator that you can then utilize. Let me see if I can go to that calculator just very quickly and just show you, ladies and gentlemen, what that calculator looks like. I'm trying to be very fancy, and in the process, I know I'm going to lose. So just excuse me for a second while I try bring up the calculator. Where did I put that calculator? All right, anyway, but yes, there is a calculator. Sorry, I don't know where.
And that's what would be filled out in that those definitions.
Yes, absolutely, absolutely. Sorry, the other question, there was another question. Someone said something?
Yeah, Ava, sorry, I just want to clarify my previous question that can you hear me?
Who is that?
How's it, Ava? It's Phil.
Hello, Philip. How are you?
Black and you.
I'm fine, thank you. Right. What's your previous?
I just want to clarify. I want to clarify one of my earlier comment questions. We can apply, assume the TERS benefit for factory and office workers. I understand that. For office workers that we don't claim the TERS benefit for at all, so you surely be allowed to calculate their salary for their salary proportionately, utilizing some annual leave that they've accrued to date.
Phil, I just want to go back.
The balance being unpaid.
I just want to go back a stage. There is no restriction on who you can claim the UIF TER for if there is a pervasive lockdown through the business and you've been paying UIF on behalf of those employees. The only issue is on behalf of the employees who you haven't been paying UIF for.
Yes, I understand that. But in this case, this would be more beneficial to employees. From an employee perspective, it would be more beneficial for office staff who are earning more to rather take away from the annual and unpaid leave than the TERS benefit.
No, but hold on a moment. I think it's important to say this. The TER benefit doesn't cancel out your taking normal leave from them. The TER doesn't cancel that out. All it does is it subsidizes it by 6,850 rand. So you can say to office staff, you are being asked to take, because of the level at which you're earning in the business, you're earning way beyond 17,750. Because of that, we will, the first 6,850 will be paid by the TER, and the balance will be set off against leave that's due, and eventually will be set off against unpaid leave. In other words, we won't pay you.
Which is then the period outside of the lockdown, though, because the TERS benefit pays you for the lockdown period.
Yes.
And I understand the regulations, then that employee can't receive any other remuneration for that lockdown period. So then what you're saying is then you can only claim annual and unpaid leave for the remaining period when, let's say, you open up again.
No. That's not the way it works. You are entitled to say, I need to pay you 1,000 rand. TER will give me 300 rand. The other 700 rand, I've still got to pay you, but I will set off what I'm paying you. I will set that off against your normal leave, which is due. You're entitled to say that.
So then we're saying, so then every company should submit TERS for every single employee in their company.
If it's lockdown, every company should submit a TER application for all employees on whose behalf you're paying UIF. There's no preclusion.
Okay, and then use that to offset the actual cost that you're paying the employee.
But remember, you are obliged to say to them, we're giving you a choice. If you don't want us to plug the gap, then we will regard it as unpaid leave. If you do want us to plug the gap, you've got to come to the party and share the risk with us, and you've got to take normal leave. So we will pay you even though we've got no income, but we reserve the right to set it off against normal leave. In plugging the gap, not in first port of call. There are some bargaining councils.
And we can use
Sorry?
Right, and we can use a combination of annual and unpaid leave in that gap.
Of course, if they don't have enough annual leave due to them, absolutely.
Yeah.
But you cannot use sick leave. And I need to emphasize that, Phil, you can't use sick leave. Sick leave has to be restricted for utilization of medically induced, I nearly said coma, of a medically induced quarantine or prolonged sick leave. There are some bargaining councils that have, for example, the Clothing Bargaining Council have said to its members, we please want you to give 5 extra days of special leave to the person so that before you take off normal leave to plug the gap, you give them 5 extra days of special leave to plug the gap. Because in that instance, the employers at the Bargaining Council have been convinced to pay 5 extra days of leave in terms of sharing the risk with the employees, and then the employees' risk is their normal leave, which would kick in. So it would be TERS, it would be special leave, and then it would be normal leave, and then unpaid leave.
Okay, but we're not obligated on the special leave.
No, you're not, unless you're party to a bargaining council that has agreed on special leave, or unless you have a plant-based agreement with your trade unions that has agreed on special leave. And we will ignore that last swear word of exasperation, whoever that came from. Right, moving on, ladies and gentlemen. Any other questions? I know this is exasperating.
Hello?
Hello? Hello?
Hi, can you hear me?
I can definitely hear you.
Okay, thanks. I just have a few questions with regards to the CSV file that needs to be completed.
So thank you. So I am sending, when I send the documents to you, you'll get the spreadsheet if you're doing payroll essentially manually, and then you'll get 2 files that you use, CSV files that you'll use should you be using a payroll system. Right, ask your question.
Okay, so if I'm using a payroll system, how do I get the CSV file? Do I manually have to still type it in onto the CSV file, or how does that work then?
I think well, I don't know who that was. That wasn't me, by the way. But what you'd have to do is you would have to speak to your payroll company, because I'd imagine they'd have a patch for you. I would imagine that most payroll companies, I know Sage has already got, where they're saying, don't use that file from the UIF department. We've created a patch for you that will do it automatically.
Okay, and if you're doing it now manually, I've seen that they would like you to put in a termination date But we're not terminating the employees.
What they mean is
what
the termination date means is the date you went on lockdown. For everybody, it should be.
Okay, so it will be the.
Whenever we were put onto lockdown.
26.
Yeah. Whatever the date was, yeah.
27th, because it was 26th at 12.
Okay, so it will be 27.
Sean Rogers says, how can we receive the files if we did not register directly with you, but we sent the link to... Sean, just send me a WhatsApp and I'll send you the files. It's pretty simple. Nadia says, can we allow them to take leave? And when the UIF payment comes in, we add it back to their leave balance. Yeah, Nadia, that's a good question. If you've already processed leave, you can either reverse the leave and simply wait for the UIF to come in and then simply process the leave due, or you can process the leave ordinarily as you've done and wait for UIF to come back, in which case you will simply add it back to leave. If you're going to do that, you need to prepare a letter and send it to your staff with their payroll notice, with their pay slip, to say, please note, your leave has been processed, but we have applied to UIF for TER. Once we get TER, we'll add your leave back. We'll calculate it. We will inform you of the number of days of leave we're adding back. That's a wiser way of doing it, by the way, because that way you do not need to get into massive calculations on the number of days to plug the gap. Annalise says, Annalise has just sent me Annalise, please just WhatsApp that to me, please, on 082-880-5316, because when we finish this discussion, all the chat disappears. All right. Any other questions? Any final questions? Otherwise, we're going to log off, and I'm going to say thank you for joining me.
I have one, sorry.
Okay.
That's on the CSV file, they ask for the national minimum wage. So now I know they've given like a whole list.
When they ask for the national minimum wage, they're saying, what is your national minimum wage that you're paying against? The default is the national minimum wage. If there is a bargaining council or a statutory determination minimum wage, you have to put that in as opposed to the national minimum wage. But then what you have to do is you have to but you have to append to that a copy of that schedule of the national minimum wage.
Otherwise, if you just like a normal, not part of a bargaining council or something,
then it's 3,500
rand.
Yeah, absolutely.
Okay, cool. All right, thank you.
No, thank you. Right, I just want to check anything final. I am blonde. You'll have to say that number again. Annalise, yes, it's 082-880-5316. 082-880-5316, and it's just send me a WhatsApp to that number, and I'm only too happy to oblige. Ladies and gentlemen, thank you so much. It's been fun. And any questions, please feel free to ask them via WhatsApp. Oh, sorry. The question is, do you have notes for dummies? Rene, I'll be sending this presentation out. I'll also be sending all of the files out, as well as the MOA and the calculator out again. When I say sending out, you will get an email from me, which, as if it was the invitation to attend the conference, this webinar, that I attach the files to, or it would be a straight email, but that's how they will be distributed. Thank you, everybody, and I appreciate your time.
Thank you, Ivo.
Thank you.
Bye-bye.